Oh no, I don't like that one. Good evening, people. Good evening. Back with part 7. Today they finished. Day 7 was closing arguments. They're on day 8. They started doing they finished the closing arguments and they started doing jury deliberations, and they did resume. They cut it off for the night, so not gonna be a verdict to today. I'm trying to catch up. I don't know how. I don't know. I don't know how long they actually finished. How long they went into today. I know they did do a jury is out watch, but I don't know how long they took. So what I'm going to attempt to do is get through this 8 hour live of the closing arguments between both sides. And if I can, I will go to what they did today up until they sent the jury out so that in real time we can be watching tomorrow. I'm trying to catch up. We'll see. I ain't got no more time. I'm wired. I had one too many energy drinks. And so, without further ado, day 7, closing arguments. Hopefully they ain't finna play no more goddamn videos, so I need to screen. Hopefully I don't have to screen share anything, because they done playing.
This one there real quick. Literally within the next 1 minute.
Them niggas finna say, yo, we trying to acquit. The judge said, fuck no.
Proof is all pointed towards innocence for Jerry. Based on that, I would ask that this court would consider my motion for approval. Yeah, but Dimitri stated we would do the motion for judgment pursuant to Rule 29, incorporate the arguments made in the state of closed group, ask the court to take this case from the jury. It's really done. The rules there for a reason. The court has the authority. Now, I would adopt what Mr. Stingel just said regarding Rule 29. But when you couple that with the character law agency regarding the strengthening of presumption of innocence, measure against the standard of can a reasonable juror find beyond reasonable doubt to a moral certainty that Justice Smith committed any of these crimes, I would say, just as Mr. Stingel said, this is the right case for Rule 29 judgment acquittal. In order, if nothing else, purposes of justice, courtesy law, and at the same time, that's what the 13th juror does. It avoids the idea of a jury getting back there and being misled, confused, compromised verdicts, something that is not allowed. Your Honor, been here for this entire trial, and it's heard all proof. I would ask that you grant Justice Smith's motion for the
For the same reasons as before, we believe we have jury questions. I understand the defense has arguments and things, but we have jury questions properly with the jury, and we believe it should go to jury all counts.
Listening to the motion that had been presented by the defense in this matter and incorporating the reasoning that the court had previously gave, the court does acknowledge that the state has, or the defense has presented proof, and as far as their theories, but the court does not believe that the proof that's been presented negates the proof that has previously been presented. So looking at the evidence that was presented, sufficient proof with regard to Mr. Daenerys being Demetrius Haley and Justin Smith to allow the jury to take this matter for their consideration, having looked at the evidence in the light most favorable to the state as required by law. So the court will deny the motion at this time. Proceed with the charging of the jury. With regard to the jury instructions, defense, if you all have any proposed instructions to include, present argument.
Yeah, I submitted an instruction regarding flight, and I stand on the submission that's been made. I had like the language catered. I know it's a unique motion, and I know that this is a different case. Only that flight instruction goes towards the guilt of the defendant. In this particular case, the flight instruction goes to the defendant's mind, in the mind of the alleged victim, and the motivation to have put up the type of struggle that he did in this case. And it also goes towards the fact that, number one, those sworn officers had a duty to try to apprehend this fleeing suspect. Number two, that they had a duty that did not cease until the alleged victim put his hands in handcuffs and submitted to the handcuffing and allowed the officers to pat him down for safety reasons. Based on that, I believe that the instruction regarding flight, in a case where they're asserted, I think that the truth bears out that he fled on 3 different occasions. Number one, from the blue lights at 385 Riverdale. Number two, from the first scene crossing Brands. Number three, from the eye contact that was made between and the team to have a conversation with Darius Bean, who was making communication based off of the description issued in the photo. Based on those things, we think we're entitled to that flight instruction.
Judge, Mr. Haley joins in the request for that instruction. Now, it's everything Mr. Perry said on behalf of Mr. Dean. And I was just to add briefly that it's very important that the officers are responding to resistance as trained. And the presence of the psilocybin mushroom, presence of the stolen ID, the presence of the stolen credit cards, debit cards, can be in the mind of Tyree Nichols when he flees on those 3 occasions. That is something that is appropriate to consider, and it is a factor that the jury should be able to consider in determining Mr. Nichols' state of mind, his actions, and the propriety of these defendants, Mr. Haley specifically, the propriety of the force that he used and the use of force.
I would join what Mr. Perry and Mr. State said, and I would add that we have video evidence presented to the jury of what Mr. Nichols was doing 6705 Ridge Crest, which is part of the flight. State, you know, response.
For the same reasons that we stated before, we asked Your Honor to deny it. Again, this is not a request that the defense be allowed to argue the things that were stated. This is a request for the flight instruction. And the flight instruction is very specific and refers to emphasis to be made against a defendant and is inappropriate in this case.
So listening to the arguments with regard to the inclusion of the flight, the court agrees with the state as far as the court does not and will not deny the defense from their making an argument with regard to what they believe the state of mind was, what the actions required of the officers that night. But with regard to the flight instruction, which is included in the Tennessee Pattern Jury Instruction 42.18, that specific instruction which reads the flight of a person accused of a crime other than evading arrest is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt the defendant fled is a question for your determination. It goes on to say that if flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of a crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight if flight is so proven. We got all the other evidence and we decide the guilt or innocence of the defendant. This instruction specifically is in regard to the defendant and the actions of the defendant and the inference of guilt based off of the potential flight. So the court will deny the request of a flight instruction and allow that to be argued by the attorneys. Any additional instruction?
Your Honor, on behalf of Demetrius Haley, I have filed the written proposed defense theory. I will, as soon as I get a chance, put it in case caption and respectfully submitted it and file that for the record. But what I have submitted by email has been filed with the court. I would ask that it be included as Demetrius Haley's theory of contention. The state has a theory of contention. It's the indictment. It's been read, and it will be in the jury room. This is Demetrius Haley contests the indictment, has introduced evidence, and this submitted instruction is his theory and contention. I believe that the Tennessee Court of Criminal Appeals, in state appeals are citing State versus Phipps, which have been furnished. They say that the defendant is entitled to have every issue of fact raised by the evidence and material to his defense submitted in proper instructions to the jury, as well as, upon request, an instruction which outlines the defense theory of his case. While it is not, and it is that authority that I suggest that this is appropriate. While it is not binding authority, in Phipps, the Tennessee Court of Criminal Appeals went to other jurisdictions to look for persuasive authority because there was what they considered a dearth of Tennessee case law. In that case, that was the diminished capacity case that I submitted. So I'm submitting also the Sixth Circuit case, United States versus Garner, cited on the instruction. And the language in it, the Sixth Circuit says, it is our opinion that the trial judge should have presented the defendant, Lorraine Brown's theory of the case in his instructions to the jury. In a criminal case, it is reversible error for a trial judge to refuse to present adequately a defendant's theory of defense. The trial judge was not required to adopt the language suggested by a defendant in the court's instructions. However, when a theory of defense finds some support in the evidence and in the law, a defendant is entitled to have some mention of that theory in the instructions. Even when the supporting evidence is weak or doubtful credibility, its presence requires an instruction on the theory of defense. I skipped the internal case cites there. Your Honor, there's evidence to support the theory that Mr. Head has submitted. What has been submitted is not argumentative. It is simply a statement of facts in evidence that tend to negate the state's theory of the indictment. And I would request that the instruction proposed and emailed and filed be submitted.
The theory of defense spoken about in Phipps and in the other cases are instructions on the law. So if the defense is some type of self-defense, then the judge has to instruct the law on self-defense. If the defense is diminished capacity, then the judge has to instruct the law on diminished capacity.
So can't handle the truth. You go act like we wasn't a part of a 4-hour live over on the stoop. That's how you gonna do me, huh? You just gonna act like we didn't just leave the stoop. Jeez.
Wouldn't be fair not to, and that's what those cases stand for. Not for the submission of a factual statement by defendants reporting factually, this is my theory of defense. Rule 30 doesn't contemplate that, and no Tennessee case has proved that.
With regard to the defense theory, you know, the Rule 30 is large and the case law that's represented. All of the case law that the court has looked at references the inclusion of law. With regard to theories that's been presented, the court understands that the defendant is at least stating on purpose of the record that it's not argumentative, but this is the defendant's version of the facts that have been presented, which in essence are argument. So the court, looking at the proposed defense theory, does find it to be argument that should not be included in the jury instructions. Also, that the jury instructions and the law that has been cited is not intended to incorporate such arguments, but that those things to be included in the jury instructions were reference to law that may be in support of the defense theory, not the defense theory in and of itself. And so the court will deny the request to include this proposed instruction. Are there any other proposed instructions?
Nothing to say.
All right. If there are any other matters that we need to address before bringing the jury instructions and getting ready to charge the jury. All right. We will go ahead and prepare the jury instructions. We will prepare to charge the jury. We'll stand in recess while we prepare those instructions. Those instructions are a little bit lengthy, so it may take us a few minutes to get those ready, but we'll stand in recess until the instructions are prepared.
Cross recess.
Well, damn. That wasn't no closing arguments. They went straight to recess. Well, hold on then. They started at the 53-minute mark, and at the hour and 13, they out. Oh, he really gonna tell? Oh, I guess that's the boring part. He gonna tell the jury their instructions. When the fuck are the closing arguments? Oh yeah, I'll probably get through part 8 because I'm 15 minutes into the live and we're going into 2 hours in this one. And they ain't back yet. Well, the judge is back.
The court is going to give you
This
the law.
judge look like a
You're
tuba
going to have a
actor.
notebook that has the jury instructions. You're free to mark and make notes as we go along. Unfortunately, the law requires that I read this into the record. Not to insult your intelligence, I'm sure you want to read it, but the court needs to make a record of the instructions that are being presented.
Oh wow, he said he got to do it for a record.
Instructions. You're welcome to follow along as you choose. State of Tennessee versus Tyree, Demetrius Haley, Justin Smith, indictment number 2300241. These three defendants, Darius Bean, Demetrius Haley, and Justin Smith, are being tried at one time. But it must be remembered by you, the jury, at all times, that even though the defendants are being tried together, they are separate and distinct and must be treated as such by the jury. When the word defendant is used in these instructions, it applies equally to Darius Bean, Demetrius Haley, and Justin Smith, unless otherwise stated. Likewise, whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural. The first count of indictment 2300241 charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of second-degree murder. Embraced and included are the lesser-included offenses of facilitation, second-degree murder, voluntary manslaughter, facilitation, voluntary manslaughter, aggravated assault resulting in death, facilitation, aggravated assault resulting in death, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation, criminally negligent homicide. The second count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of aggravated assault, acting in concert. Embraced and included are the lesser included offenses of attempted aggravated assault, facilitation of aggravated assault, assault, and attempted assault. The third count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of aggravated kidnapping with bodily injury. Embraced and included are the lesser included offenses of attempted aggravated kidnapping, facilitation of aggravated kidnapping, kidnapping, attempted kidnapping, facilitation of kidnapping, false imprisonment, and attempted false imprisonment. The fourth count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith.
They overcharged them.
With deadly weapon. Embraced and included are the lesser included offenses of attempted aggravated kidnapping, facilitation aggravated kidnapping, false imprisonment, and attempted false imprisonment.
They overcharged them. So if they get some of these lesser charge shit, it's the DA's fault for giving them the goddamn option of a whole bunch of this other bullshit that he's reading out.
The fifth count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of official misconduct, unauthorized exercise of official authority. Embraced and included are the lesser included offenses of attempted official misconduct and facilitation of official misconduct. The sixth count charges the defendant Darius Bean, Demetrius Haley, and Justin Smith with the offense of official misconduct, refraining from performing a duty. Embraced and included are the lesser included offenses of attempted official misconduct and facilitation of official misconduct. The seventh count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of official oppression. Embraced and included are the lesser included offenses of attempted official oppression and facilitation of official oppression. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and under the law given them by the court, render their verdict with absolute impartiality. The jury are the sole judges of the facts and of the law as it applies to the facts in the case. In making up your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The jury, in no case, should have any sympathy or prejudice or allow anything but the law and the evidence to have any influence upon them in determining their verdict. They should render their verdict with absolute fairness and impartiality as they think the truth and does justice dictate. Every fact and circumstance in the case you may consider in arriving at your verdict. The indictment in this case is the formal written accusation charging the defendants with the crime. It is not evidence against the defendants and does not create any inference of guilt. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks I have made do I mean to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you understand the evidence and apply the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The evidence in this case has been completed, and it is my duty now to instruct you on the law. The law applicable to this case is stated in these instructions along with your preliminary instructions, and it is your duty to consider all of them carefully. The order in which these instructions are given do not indicate their relative importance. You should not single out any one or more to the exclusion of another or others, but should consider each one in light of and in harmony with the others. As previously stated, the defendants have been charged by the state of Tennessee in the indictment with second-degree murder, aggravated assault, acting in concert, aggravated kidnapping, 2 counts, official misconduct, 2 counts, and official oppression.
Kidnapping? They didn't take the nigga nowhere. How you kidnap somebody that didn't move? You didn't move without their. Where did they move him to?
You are not to assign any meaning to their numbering. The court will now explain the law.
Seriously, how did the kidnapping charge come when he ran from the first scene? They caught him, they beat him, they handcuffed him. Where the fuck does the kidnapping come? After the ass whooping and the handcuffing, he was there until paramedics arrived, and then paramedics took him to the hospital. When the fuck did they kidnap him? Hence why I say they overcharge these people. And the jury has to consider all these charges when going through this evidence to see what they're guilty and not guilty of. And they got to see some stupid shit like kidnapping. This one shouldn't be on here. All the other shit, yes. Kidnapping, where did they move him to without his will? They didn't try to move him anywhere once they tackled him and got him on the ground. They weren't dragging him or any of that stuff. So where does the kidnapping charge come from? It's a good old state of Tennessee for you, though.
In count 1 in the indictment, second-degree murder of Tyree Nichols. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Tyree Nichols. And 2, that the defendant acted knowingly. Here, knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means that a person acts intentionally when it is a person's conscious objective or desire to cause the death of the alleged victim. The distinction between second-degree murder and voluntary manslaughter is that voluntary manslaughter requires that the killing result from a state of passion, produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Facilitation of second-degree murder. Any person who facilitates the offense of second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit second-degree murder, but did not have the intent to.
This is exactly why I said I feel like they're going to skate on the murder charges because facilitation of second-degree murder, none of them are going to get that because there's no way the jurors can prove, nor did the prosecution believe that any of those men set out to kill dude. Because I mean, like, let's just be honest. If they wanted to kill him, they would have shot him. They pulled out tasers, they pulled out batons, they pulled out pepper spray. They yelled, "He grabbed my gun," and not one shot was fired. So if that was their intent to just kill a motherfucker, they would have done that. And they would have been slow on the getting the paramedics there to the scene. Now, even in the body cam video where they bragging and talking about the shit, they even asked dude, like, "What are you on?" They were like, what you take? Like, what are you on? They were amazed at how strong he was. They asking him this while also talking to each other about how it took 5 of them to take him down, because it took 5 of them to get him in handcuffs. When it was 2 of them at the initial stop, they couldn't get him. So yeah, I think they're going to miss the mark on the second-degree murder. They're probably going to get in the facilitation. They're probably going to get them on some type of aggravated assault or some type of excessive force charge. They're the other misuse of powers. It's not going to be murder though. I'm not feeling it. I don't think they proved I don't think they did a good job of proving that these gentlemen tried to murder this man. Did they try to whoop his ass? Yes, they definitely tried to whoop his ass. They bragged about it. They had no idea the man was going to die. He died as a result of the injuries that happened during that, but in that moment, they didn't know the man was going to die. When he left on the ambulance, they didn't know the man was going to die. He was talking, he was moving. Shit just, they need to suffer the consequences? Yes. What that looks like, I don't know. I definitely don't believe they should get off scot-free. They need to do some type of time for what they did, because they can even admit that they were excessive, like kicking a motherfucker in the head. That's the one thing that stood out to me that the prosecutor said, and I had to pat him on the back. Doesn't a man have a right to protect himself in the natural reaction after getting punched or kicked in the head or the face, to draw up, to try to move your hands towards your head, to put your hand on your forehead and be like, ouch, it hurts, things of that nature. So that prosecution did a good job with that one. But I don't think these guys are going to get any of the murder charges, the facilitation of murder, or any of that.
Or assist the commission of the offense, or to benefit in the proceeds or result of the offense. And two, that the defendant furnish substantial assistance to that person in the commission of second-degree murder. And three, that the defendant furnish such assistance knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct, so the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to a result of the person's conduct, when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intended and intending mean that a person acts intentionally with respect to the nature of conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute second-degree murder and definitions have been set out on page 4. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. To define the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Tyree Nichols. And 2, that the defendant acted intentionally or knowingly. And 3, that the killing resulted from a state of...
So are they charged with voluntary manslaughter or second-degree murder?
In an irrational manner. Intentionally and knowingly have previously been set out in these instructions. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which render the mind incapable of full realization of voluntary manslaughter. Any person who facilitates the offense of voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of voluntary manslaughter. And 3, that the defendant furnished such assistance knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute voluntary manslaughter and the definitions have been set out on page 7. Crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to Tyree Nichols. And 2, that the act resulted in the death of another. Bodily injury includes cut, abrasion, bruise, burn, or disfigurement, physical illness, or impairment of function of a bodily member, organ, or mental faculty. Knowingly and intentionally have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Any person who facilitates the offense of aggravated assault resulting in death is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That did not have the intent to promote or assist the commission of the offense or benefit from the proceeds or results of the offense. And 2, that the defendant furnish substantial assistance to that person in commission of the aggravated assault resulting in death. And 3, that the defendant furnish such assistance knowingly. Here, knowingly intended and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The essential elements necessary to constitute aggravated assault resulting in death and definitions have been set out on page 9. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proof beyond a reasonable doubt the existence of the following essential elements. 1, the defendant killed the alleged victim, Tyree Nichols. And 2, the defendant acted recklessly. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of or consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Here, intentionally and knowingly have previously been defined in these instructions. Facilitation of reckless homicide. Any person who facilitates the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a reckless homicide but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of reckless homicide. And 3, that the defendant furnished such assistance knowingly. Here, knowingly intended and intending have previously been defined in the instruction. The requirement of knowingly is also established as intentionally. The essential elements necessary to constitute reckless homicide and definitions have been set out on page 11. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. The defendant's conduct resulted in the death of the alleged victim, Tyree Nichols. And 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowingly, and recklessly have previously been defined in these instructions. If you find, beyond a reasonable doubt, that a defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's action need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. Facilitation of a criminally negligent homicide. Any person who facilitates the offense of criminally negligent homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knew that another person intended to commit a criminally negligent homicide, but did not have the intent to promote or assist the commission of the offense or benefit in the proceeds or result of the offense. And 2, the defendant furnished substantial assistance to that person in the commission of criminally negligent homicide. And 3, the defendant furnished such assistance knowingly. Here, knowingly intended and intending have previously been defined in these instructions. The requirement of knowingly is also established if the defendant acted intentionally. The essential elements necessary to constitute criminally negligent homicide and definitions have been stated. The court will now explain the law applicable to count 2 in the indictment. Aggravated assault, acting in concert. Any person who commits the offense of aggravated assault, acting in concert, is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to Tyree Nichols. And 2, that the act resulted in serious bodily injury to Tyree Nichols. And 3, that the defendant committed the offense while acting in concert with 2 or more other persons. Acting in concert means such conduct that would make one criminally responsible for committing or facilitating the offense. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury, intentionally and knowingly, have previously been set out in these instructions. Criminal attempt, aggravated assault, acting in concert. Any person who attempts to commit aggravated assault, acting in concert, is guilty of a crime. You find a person guilty of criminal intent, the state must have proven beyond reasonable doubt the existence of the following essential elements. One, the defendant intended to commit the specific offense of aggravated assault acting in concert. And two, the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending mean that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute aggravated assault acting in concert and definitions have been set out on page 15. Facilitation of aggravated assault acting in concert of Tyree Nichols. Any person who facilitates the offense of aggravated assault acting in concert is guilty of a crime. You can find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knew that another person intended to commit an aggravated assault acting in concert, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And two, the defendant furnished substantial assistance to that person in the commission of aggravated assault acting in concert. And three, the defendant furnished such assistance knowingly. Here, knowingly intended and intending appears to be defined in these instructions. The requirements of knowingly is also established and is shown that the defendant acted intentionally. The essential elements necessary to constitute aggravated assault acting in concert and definitions have been set out on page 15. Reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. You can find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant recklessly caused bodily injury to Tyree Nichols. And two, that the act resulted in serious bodily injury to Tyree Nichols. And three, that the defendant committed the offense while acting in concert with two or more other persons. Here, recklessly means a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when a person is aware of or consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of reckless is also established if it is shown that the defendant acted knowingly or intentionally. Acting in concert, bodily injury, serious bodily injury, knowing and intentionally have previously been defined in these instructions. Facilitation of reckless aggravated assault. Any person who facilitates the offense of reckless aggravated assault is guilty of a crime. If you can find a defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. One, the defendant knew that another person intended to commit a reckless aggravated assault, but did not have the intent to promote or assist the commission of the offense or to the benefit or to benefit.
I think I'm a bit confused here because why is he reading all this shit off if they're not charged with all this shit? They can't be charged with second-degree murder, involuntary manslaughter, and all this other shit that he's reading. So why is he reading it? They don't get to decide what they found guilty of. They have to be, I mean, they do get to decide what they're found guilty of, but they don't get to change. If it's not what they were charged with, you can't add it to it. So if they weren't charged with first-degree murder, you can't say you're guilty. First-degree murder, you're guilty. Involuntary manslaughter. It has to be what they're charged with. And you can't be charged with 3 different murder charges. He's named at least 3 and reading this shit. And I feel like they just wasting a whole bunch of the court's time at this point. I digress.
In the proceeds or result of the offense. And two, the defendant furnished substantial assistance to that person in the commission of reckless aggravated assault. And three, the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established that it is shown that the defendant acted intentionally. The essential elements necessary to constitute reckless aggravated assault and definitions have been set out on page 18.
Aggravated assault, reckless aggravated assault, reckless endangerment.
You define a defendant guilty of this offense.
So what he reading off is pretty much the state just threw about 60 charges at them and hoped that 2 or 3 stick. That's tacky prosecuting.
Proven beyond a reasonable doubt the existence of the following essential elements. One, the defendant engaged in conduct which placed or might have placed another person in imminent danger of serious bodily injury. And two, that the defendant acted recklessly. For the threat of serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to mere possibility of danger. To convict the defendant, the state must have shown beyond a reasonable doubt that a person or a class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of serious bodily injury. Serious bodily injury and recklessly have previously been defined in these instructions. Assault. Any person who commits an assault upon another is guilty of a crime. If you find a defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant caused bodily injury to Tyree Nichols. And 2. That the defendant acted either intentionally, knowingly, or recklessly. Bodily injury, intentionally, knowingly, and recklessly have previously been defined in these instructions. Attempt to commit assault. Any person who attempts to commit assault is guilty of a crime.
Okay, y'all, I'm about to skip through this shit. This here is ridiculous.
The state must have proved beyond a reasonable doubt. 28.
He gotta read this shit.
Risk of harm.
And he reading it off paper instead of a computer screen. So they killed a lot of trees for this. God damn, did this nigga read this shit for an hour?
Attempt to commit false imprisonment.
This is ridiculous.
Aggravated kidnapping under intended.
Hell no.
And 2.
I know all them jurors is like, bruh, can we get to the closing arguments, please?
And 2.
I'm trying.
And 4.
I don't know what this nigga like. I don't know how much of this shit he reads.
Facilitate identity.
Okay, I can't take this. This nigga is reading this shit for over an hour.
Opinion of your fellow jurors.
Man.
Or for the mere purpose of returning.
And they showing the police officers. I thought he was done because they showed.
In order of consideration, guilty of attempted.
They just want to put. And then after all that fucking reading, this nigga, I know you do need a water break, nigga. All that shit you just read for an hour and 30 minutes.
Or you've received all the proof in this case for your consideration. You've received the law. And as we talked about in the very beginning, now there will be the opportunity for the attorneys to submit their final arguments. We will begin with the state, and the state's ready.
All right, let me see. Let me try for the third time. Fuck it. Let's see what we can get. Hold on, let me put that on playback speed. Let me fix that. I like how we can slide it and adjust it to the speed that we want. 1.35. That is perfect. Click that. All right. 342.23. Let's see what we can do here. 342.23. Dear prosecutor, fine. Not the white one. The black one, fine. Damn it, why can't I find 342? Fuck it, we'll just go from there. Let me try to share it now and see what it does for us. All right, share.
Explained to before, you've received all the proof in this case for your consideration. You've received the law. And as we talked about in the very beginning, now there will be the opportunity for the attorneys to submit their final arguments. We will begin with the state, and the state ready to present their final argument.
Yes, okay. Remember us to have for dinner 5. Tyree was her baby. Youngest of 4. 29 years old. It's Saturday. He left the house that day. She said he came in the kitchen and talked to her before he walked out. Saw her taking the chicken out. Asked what she was making. Sesame chicken. If you remember her testimony, she said he kind of made a rub it on his belly, like, yum yum. I'll be home for dinner. But he didn't make it. "29 years old. That house on Castlegate. That's what Tyree looked like. Tyree had a special relationship with his mom. You heard her talk a little bit about it. I don't know if y'all noticed in one of the pictures that was introduced as part of the autopsy that his mom's name tattooed on his shoulder, Rovon. Tyree left that afternoon, and he never made it home for dinner because he came into contact with these officers. And the next time Ms. Rovon saw her son, he was in the hospital in the wee hours of January 8th, and this is what he looked like. After coming in contact with these officers. And he almost made it home. He's so close. There's a map that's been introduced, and it shows you all the locations that we talked about. Look how close they are. You heard Ms. Rovon testify that to get to the scene where all this happened, just basically 80 feet from her front door. And at that first stop, when there's so much screaming and so much chaos, one of the things you hear Tyree say, just trying to get, he's trying to get home to his mom's house. But he doesn't make it. One of the things that was said in trial this week. When the defense attorneys asked a question and said, so Tyree was whipping y'all's tail. I don't know if you remember this. Tyree was whipping y'all's tail. Tyree, the smallest person out there, 5 officers. Tyree was whipping y'all's tail. To show you pictures that were introduced into evidence of each of those officers at the end of that night. Officer Bain. Officer Emmett Martin. Officer Justin Smith. They were getting their tails whipped. This is them that night, after the fact. Can you see the picture of Tyree again? And about the same time those pictures are taken by TBI, Mr. Rodney Wells, Tyree's stepdad, takes this picture at St. Francis Hospital. So Tyree was whipping their tail. That's what they want you to believe. I know y'all seen a ton of video this week. When you go back to deliberate, you'll have that video. You'll be part of it that you want. You'll be able to ask you to listen to things. This is different. A portion of Bean, and I'm gonna just set it up a bit. Y'all seen it. Bean is the officer who's riding with Officer Mills. Officer Mills testified that he sees someone matching the description in the rear view. They kind of do a U-turn, and then you see Officer Bean jump out of the car and start sprinting towards Tyree. And if y'all remember, as Officer Bean gets to Tyree and tackles him to the ground, shortly thereafter, his body worn camera, which is worn here on the front of the chest, falls off. So we can face down, so it goes black, but you can hear the audio. And I want you to watch and listen for it. And we're going to listen to the portion where everything happens to Tyree. We're going to hear those first 2 kicks from Officer Martin, where Venus Smith had pulled him down. We're going to hear the punches. And then the final 2 kicks from Haley and Martin. And I say we're going to hear because even though this body cam is on the ground somewhere over here, we don't really know where, some of those impacts you can hear. You can hear the kick making contact. You can hear some of those punches. And keep in mind, that camera is not on his chest. That camera is over on the ground somewhere. And you can hear it. So when you listen to that, more so what I want you to listen to is Tyree. Because these hear Tyree say. And the first thing that you'll hear, really listen. How close is he to home? How close to his mom? So listen to that. And then listen to what Tyree sounds like as the video goes on. Moaning, pain, but listen all the way through. And if we can have the lights turned off, and we'll play that video. And y'all will remember, you're probably familiar enough by now, but every time a body cam turns on, there's about a minute that goes by that there's no audio. I know it's hard. There's other noises in here. He says, help me. Help me. Three times. You know what happens right after that third time? He me. And Haley runs in and kicks him, and then Emmett Martin kicks him again. And those are the last words. Me. And who is supposed to help him? Those guys. They got a duty to help. And they don't. No. No witness told you Tyree punched, Tyree kicked, Tyree cussed. He didn't do any of those things. Officer Mills was there. He told you. Officer Hemphill, the guy from the first scene. None of that. Help me. Who was going to help him? When he's laying on the ground right there, when you hear him say, help me, resisting or surviving, trying to survive. Did y'all hear that first kick that we called the soccer kick? You could hear it make contact in that video. You can hear that kick. Resisting or surviving. I'm going to take y'all back to last week when we were still in Chattanooga. We'll shift gears. I'll remember during jury selection, we talked so much. There was the Rock City stoning. Remember that? And there was a robbery. I talked a little bit about the movie Ocean's 11. Everybody remember that? We were talking about criminal responsibility. And the judge is giving you the law now. It's page 58 of your jury instructions. If you want, you can follow along. I'll put it on the screen. As we talked about last week, there's two different ways. Okay, two different ways you can be criminally responsible for conduct of another. Both of these apply in this case. And we're going to find those two different ways in the second and third paragraphs of page 58. So we got it from we're talking about this week. We were talking about examples of bank robbery. Five officers out there. 5 officers. It's two different ways. First, another. You'll hear more about that evidence.
All right, yeah, it said my browser lost connection to my screen share audio. I'm gonna try one more time. If not, I'll go back to the if it doesn't work this time, I'll go back to just the audio. I'm gonna say 3 days in a row. That would just been too much. Okay, let me skip her back since it never stopped playing. Because she looked like she was trying to make a point.
The defendant, here we go. These are the things: solicits, directs, aids, or attempts to aid.
Has the screen popped up yet? Okay, yes, it ain't popped up on my end. All right.
Criminally responsible for the behavior of another. The first way is in paragraph 2. The defendant is criminally responsible for an offense committed by conduct of another if acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or results. The defendant, here we go, these are the things. Solicits, directs, aids, or attempts to aid another person to commit the offense. And I'm going to focus on directs. I think that'll come up in our proof. You'll hear more about that evidence as I go on. Aids, attempts to aid. Okay? That's one way you can be criminally responsible. Another one, and a huge one in this case, is found in paragraph 3. The defendant is criminally responsible for an offense committed by the conduct of another if having a duty imposed by law, and here that's what we're functioning under, imposed by law, to prevent commission of the offense and acting with the intent to benefit in the proceeds or results of the offense, or to promote or assist its commission, a defendant fails to make a reasonable effort to prevent commission of the offense. Okay? Aids, attempts to aid, or duty. You go through, you get back in the jury room, you go through these deliberations, and you're considering the conduct of these individuals. You have to consider it under this umbrella of criminal responsibility. And when you read the jury instructions, if it says the defendant, it's the defendant or one for whom he is criminally responsible. Okay? I want to point that out before I go further. And the other thing I want to look at quickly is page 4. And that is the instruction the judge just gave you. And this is page 4. If you want to look, we'll put it up on the overhead as well. This is second-degree murder. And second-degree murder only has 2 elements. That's what's listed as 1 and 2. Defendant unlawfully killed the alleged victim, Tyree Nichols. 2, the defendant acted knowingly. 2 elements for the state proof. And we talked about this with y'all last week. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. Reasonably certain to cause the death of the alleged victim. Another thing I want to point out is after it defines knowingly, it says the requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally. Knowingly or intentionally, the evidence today. How do you do to this? You know, based on someone's intention, right? What did they do? Didn't do. You can also hear what they said. So keep those things in mind as we discuss evidence today. Keep those things in mind as you go back in that jury room and have all this evidence. And you can rewatch any portion today. I'm sure everyone's closing arguments. If somebody points to something that happens, make a note of that timestamp because you'll be able, if you want, when y'all go back to deliberate, if there's any questions, y'all can watch all these videos and find these things for yourselves, okay? So speaking of video, I'm about to play Mills here. He's the guy with the baton, right? Why did he was angry because he just and we heard from many use of force experts, 3, right? Each defendant called 1. And one thing they all agree on, if you're using force out of anger,
All right. right, yeah, that motherfucker's skipping a little too much. I'm about to go back to the audio 40654. Give me a second. 406, 407.
First, the batons. Why? Why did he baton it? Do you remember what he said? He was angry. He was angry because he just sprayed himself in the face. We heard from many use of force experts, 3, right? Each defendant called one. And one thing they all agree on is if you're using force out of anger or to punch, that's acceptable. And Officer Mills sat here and told you that's why he got his baton out, because he was angry. He was angry. The first video we're gonna watch is gonna be the pole cam. And that's sort of the eye in the sky, right? The pole cam video. And this is gonna be a little zoomed in. I'm gonna slow it down a little bit. And the reason I wanna do that is so we can focus on the actions of officers Bean and Smith. Keep in mind, criminal responsibility. Attempt to aid, duty to prevent. They're aiding. In the beginning of the video, remember how it all sets up. Bean runs in, tackles, and Smith gets there right after. And there's stuff going on the ground.
Yeah, we done seen this video 1,100 times.
The next thing we see is Officer Mills and Officer Martin. So there's 4 officers and Tyree. I want you to focus watching it this time. I told you see a lot of the same video, but I want you to focus on different things when you watch it. On this time, I want you to focus on Bean and Smith. Okay? Now we all remember Smith is the has on tennis shoes, right? And they have a white sole. So Bean has on a sort of head covering. You'll see him. So they're the 2, and they're pulling Tyree down. When you look at where their faces are, where their hands are, especially when Emmett Martin comes in with that first soccer kick, then with the second. And the punches, they're on either side of Tyree, pulling his arms. And Emmett Martin's doing the punching, and he describes those punches as haymakers. And do you remember Mills being asked what's a haymaker? He said it's a knockout punch. Like one punch to do it.
One hit or
We
quitter.
know from the video that Tyree gets at least 5 of those from Emmett Martin, while Bean and Smith are holding arms. Then, the next thing we see, Tyree's back on the ground, Bean and Smith are still holding down. And that's when we get Haley run in, get this kick in. As he says, beat that man's ass, swift kick. And then Martin gets another kick, all right? So think about what you see Bean and Smith doing in this version of the video.
She says she coming with the dramatic effect. Just because she coming with the dramatic effect, I'm gonna try. I can't control the rationality of this here damn internet. As y'all witnessed, the past couple shows played just fine. Tonight, it want to act a donkey. It lost connection to my mic and a whole bunch of other shit out of my control. I'm on it though. We're gonna find a way.
Then the punches, they're on either side of Tyree, holding his arms while he's getting punched. And Emmett Martin's doing the punching, and he describes those punches as haymakers. And do you remember Mills being asked, what's a haymaker? And he said, it's a knockout punch. Like one punch to do it. And we know from the video that Tyree gets at least 5 of those from Emmett Martin, while Bean and Smith were holding arms. Tyree's back on the ground. Bean and Smith are still holding down. And that's when we get Haley run in, get his kick in. As he says, beat that man's ass. Swift kick. And then Martin gets another kick. All right? So think about what you see Bean and Smith doing in this version of the video. Just to make sure Emmett Martin's on the front of the screen closest to us. Again, you know who Justin Smith is because he's got the shoes on that are easy to spot. Bean's the other guy right now holding Tyree.
Shout out to the prosecutor for putting this on super slow motion for the dramatic effect, but she should have been narrating instead of staying silent during this moment.
Y'all keep an eye on this. We see those first two kicks. After that first kick to the head, you heard all use of force experts agree and testify. That first kick, that soccer kick to the head is what? Excessive force. Unnecessary. Deadly. And after that first kick, what do we also capture? The duty to prevent. Hold him down. I mean, their faces are right there. And that first kick, you can hear it on the video. Can you imagine if you were holding the person that took that impact? You would be able to feel it. We can hear it. But they're holding him, Venus Smith. So first kick, right there. Duty to prevent, duty to intervene. Second kick, duty to prevent, duty to intervene. Then those punches come to hold him. I mean, we got all the baton strikes, but we're just putting that in another bag. And you fly his head, how it's impacted by these punches. And after each one of those punches, what do we have? The duty to prevent, the duty to intervene. That these guys continue to hold. Then he's down on the ground. So now we're two could have intervened, could have prevented, could have done something, could have just said stop. They're on top of Tyree. Because there's a little minute there where you see, they're just sort of in a pile on the ground. Tyree's on the bottom. Dean and Smith are there. Martin's kind of standing over for a minute. And it's at those moments where in the first video we heard Tyree say 3 times, officer, do you remember criminal responsibility, direct, attempts to aid, direct, beat that man's ass, runs in, kicks. Again, Dean and Smith right there when the kick took place, triggered after Taylor says beat that man's ass, does his kick, and we get Martin back in with another kick. So that's a total of 9 times. Not one person does one thing. Not even so much as say, stop. Hey, whoa, don't you think that's a little much? No. No. So keep in mind, we can hear these impacts from somebody that's on the ground somewhere over there we don't even know. And these men are physically holding Tyree's body while this is happening with their faces this close. They had tunnel vision. There's just no way. We got 9 chances. Watch. What I'm about to play is Mills' body worn camera. And again, you've seen this, but I want you to watch it with fresh eyes. And what I want you to focus on is the reaction. First of all, Mills, before he sprays, is trying to be responsible about it, right? He's like, so you don't get sprayed, right? And you will see the first time he says that, Bean and Smith step back, completely let go of Tyree and step back. Then he sprays. I don't know where that spray goes. I don't know. I mean, you watch it, you see him. He kind of steps out, he comes back in, and he says again, watch it, I'm about to spray. And this time, he sprays himself. And Martin's on the same side as Mills. And they both get it. And the defense is going to have you believe what's in the air, everybody's affected. Let me tell you if he's affected. You'll hear immediately Mills and Martin. Oh, shit. React. You'll see Martin walk away. You'll see Mills walk away because it means it hits them. It's clear. And I want you to think about this too. You've seen those bad Bob videos that they play for a number of people. Spray, or that goes into that. Think about it. You're gonna have all these bad Bob videos, but that's how it's sprayed. You see Mills say, "I sprayed myself," and you'll see him continue to react. He has to continue to walk off. You'll hear him. He sprayed himself. Martin was standing next to him. He got hit by some of it. You see Martin walk off. And this gets back to the point. What did Mills tell you? He's angry after he sprayed himself. Too. So think about what you see Bean and Smith doing. How you see Mills and Martin react to this spray. So immediately you hear Mills reacting to that spray. Oh shit, oh shit. And you see Martin have to step away. You can also see right here, that's Martin. You see that little black square? That's Martin throwing down his body worn camera. Because now, that's 20, 33, 51, about there. Gotta get back there. Now his body worn camera is gone. You immediately see Martin and Mills react to that. They get angry, and then we'll watch what they do next. And you hear Martin yelling command, see those kicks. When you have the body cam back there, you can line all this up. What about, talking about angry? Did y'all hear Mills' voice in this video? Mills, the guy who sat here and testified, and y'all couldn't hear a word he said almost because he was the softest talker you've ever seen. On the fuck out of you. You can hear anything he said on the stand. You can hear that. Because he's angry. They're angry. How they're assisting, how they're aiding, as they're holding those hands while Martin is delivering these haymakers, how close they are to Tyree, how close they are to Martin as this is happening. And you notice, you see in Mills' body cam capture some of those punches, and if you'll remember, Mills told you he heard the first stomp, he called it. He heard the first stomp, and then he looked and saw what was happening, and he turned away and walked off. Duty to prevent, duty to stop, he didn't do it. He told you. When he saw it and he heard it, he said, I knew it wasn't good and I walked away. And that's what we see him do. He just walked away.
We are east of the intersection. You can get rid of Ross and definitely.
Mills was asked, where were Bean and Smith when those first two kicks happened? His answer, right there. Where were Bean and Smith when Martin was giving those haymakers? Right there. Right there. Mills told you he didn't do anything to stop it. He didn't tell the EMTs or paramedics what happened. He regretted it. And he put it. That's Mills. So we talked a lot and looked at what Bean and Smith were doing. In many respects, you can kind of put them in the same. Brought it up, we've talked a little bit about it. But Haley is different. His attorney has brought it up on every possible occasion. Well, Haley didn't have a duty to prevent these things. He didn't say, well, of course, I agree with that. He can't report something he never saw. Of course, I agree with that. So let's talk about what Haley did do and what Haley did see. We just got a little clip of it at the end of that. What do we know about Haley? Back to the pepper spray, right? Remember the video from the first scene? Haley tries to pepper spray Tyree and sprays himself. And you see, remember that video from the first stop where Nichols helping Haley wash his eyes out, and he stays there. Right, that's happening at the same time. But once he feels like he can drive, he gets in the car and drives to this scene. And comes running in. Running. Not assessing. Listen. Says, beat that man's ass. And does a kick. And as soon as he gets done with his kick, Martin comes back in and gives another kick. We heard from 3 use of force experts. And they, all 3, agree that every use of force that Martin did was excessive and unnecessary. 2 of them Tisdale and Zwicky said, hey, said Haley's kick was fine. And he says that Haley came in, made an assessment of the scene, surveyed Tyree Nichols, and Mr. Nichols. Maybe Mr. Cameron has some X-ray vision. I don't know. Y'all have the same video that Mr. Cameron had. You watch it. You decide if that's what Haley did. As he said, beat that man's ass. And then kick. He also beat that man's ass. So, I'll leave it to you. If you agree with Mr. Cameron that Haley's kick is fine, there's another kick right after it from Martin, which triggers what? Duty to intervene, duty to prevent. Stop. Nobody so much as says the word stop one time. But then what does Haley do? After they drag Tyree, takes a picture. A little trophy pic. Let's watch just a little video. I know y'all are worn out, y'all seen it a ton. We'll watch this video, and again, we're looking at the actions of Haley. What's Haley doing? And this is gonna be the sync video. This has the poll cam video, but the audio you'll hear is from Officer Bean's body cam.
Get your hands! Give me a hand, turn around! Lay back! Lay back! Lay back! Lay back! Lay back!
So here, Dean Smith, Martin, all there. Taking 2 kicks, 5 haymakers to the head. And after that, into the what does Haley say right after he delivers that kick, after Martin's kick? That motherfucker made me spray myself. Because he's pissed, he's angry. And he is reacting out of Bean and Smith right there, duty to prevent. Then, after they drag, we start high-fiving, fist bumping, talking about who got the best legs, who did what. Haley walks over and takes a picture of Mr. Nichols. Did his expert testify he was documenting his entries? For what? For who? The 11 people he sent that picture to? Pull that picture up. So after yelling, beat that man's ass, running and kicking, hanging out, high-fiving, talking, he goes over and takes this picture and then sends it out. And what about the text thread he had with some other MPD officer, MPD officer Fox, or so it was saved in the phone. Whoever MPD Fox is must have heard about the incident. Who beat dude up last night? Haley responds, us. They relieved some folks for real? Yeah, 6 of us. Damn, I don't understand why though. I guess it's just procedure. I don't know. It's just stupid. Keep y'all head up, Brody. The city need y'all for real, for real. Appreciate it, bro. No big deal. Who beat that man up? So when you start to think about what Haley's intention is knowingly, you can look at his actions, you can look at his words, you can look at his text to know what he was thinking. What he was doing was indictment in this case, and it will say the state of Tennessee versus Fidarius Bean, Justin Smith, Demetrius Haley, Emmett Martin, and Desmond Mills. You know who's not on trial this week? They're gonna, they were found in his car days after. These officers had no idea those cars were in that car. They're going to want to talk about some mushrooms that were found in the trunk of Tyree's car. 1.77 grams. Do you remember TBI agent Chuck Baker who testified? He was asked how much is 1.77 grams, and he said a dollar bill weighs about a gram. So the amount of mushrooms that were in Tyree's trunk were. He deserved this because he had those credit cards in his car. They didn't even know. They didn't even know that stuff was there. TDI found that. But they're going to say, well, he was guilty of something, so that's why he was running. So let's just take a minute and think why Tyree was running. And this is where it gets tricky, because you got to put a lot of faith in what Emmett Martin says. Hill told you that he was out there and he heard Martin say that he had one speeding. Hill didn't see Tyree Nichols did. Improper lane change, meaning he went in the other lane without turning his blinker on. And if Hill had to arrest Tyree Nichols that night, the violation he saw was improper lane change. And fleeing, he says. If you remember that video, it was Martin's body cam. Those blue lights are on for maybe 20 or 30 seconds. Keep in mind, these are unmarked cars. It doesn't say Memphis police on this. So he has blue lights on for like 30 seconds, and then he turned them off. And if Tyree is driving like a crazy person and trying to get away from them, why then? Do you remember where they see him? At a red light, with his blinker on, waiting to turn to go into his neighborhood. He's sitting at a red light. But just blinker on, waiting to turn. And this is when they encountered Tyree for the first time. And we're gonna play just a clip from that scene. It's that chaotic traffic stop where they're all given commands. It's chaos. Y'all remember that game Simon Says? Like, and then you had to do this. I mean, and think about this too. At the other scene, after the fact, when Tyree's popped up on the car and you hear them all, they start high-fiving and talking about what happened to this stuff. One of the things you'll hear Haley say is, man, Tyree Nichols doesn't have a Why is Tyree running? I submit to you, it doesn't have anything to do with these cards or mushrooms in the trunk. I submit to you, he's running from those officers. And then the defense is also going to make a big deal about that pole cam where you can see Tyree kind of hiding behind the cars. Yeah, he is. He's hiding from them. And they're going to say things down. You watch the video. It's not there. Chuck Baker, the TBI agent, told you there's nothing there. He's not hiding anything. There's nothing there. You watch it. He's hiding from those guys. Y'all stay with me. I know it's late. I've been talking a long time. I know you're hungry. You want lunch. I got a little more to go, and then get your lunch break. It's also not the state of Tennessee versus Robert Longer. Remember the little EMT sat up here and testified? They want to say, well, he should have done this, and he should have done that, he should have done this. Well, he's there. If they hadn't done what they did, the EMT would never have had to respond. Pepper spray and tasing. Remember that first interaction at the first scene where he called Sidney Hill and said, no, it's not for me. Because they were real confused. They were like, did you call this here? He's like, no, it's, And they say, the patient, where's the patient? And he said, another patient. And they'll look that. But that's what they were responding to. And then they get there and they see what Tyree looks like. And he told you, I assume, because he ran, when they tackled him, that's how he got the injuries that I could see on his face. So don't let the defense blame shit. It's not EMT Long's fault. It's not Tyree Nichols' fault that they did what they did because he had some credit cards in his car, because he had. We hear about the acts of these defendants. That's who's on trial this week. All right, if y'all will stay with me, we got to look at the law for just a second. One thing before I do, the medical examiner, Dr. Ross. And you'll have this report, that's part of evidence when you go back there. The main thing that caused, the ultimate cause of death was blunt force injuries to the head. Based on the video that y'all have seen 1,000 times now, that doesn't surprise me. But what I'm if I talk about injuries, that's think about torque, right? And if he described how your brain is inside the skull and it's that the brain can't keep up with the skull and it tears away. And those torsional injuries are what Tyree Nichols had. That's what caused the brain trauma. And how, as Dr. Ross, when do you normally see that? Do you remember what he said that makes that significant? In a car wreck, seatbelt. You're being held in a position, and the force makes your head turn while the rest of your body doesn't turn with it. And what do we know about what's happening out there that night? Dean and Smith are holding Tyree down when those first kicks come, so his body's being held stationary while that force goes to his head. The force of the first kick, the force of the second kick. And same thing when we have those haymakers, those punches. If you got punched with one of those, you just fall down. Your body would go with the force of the punch. If you're being held, you can't. So look at that report. All right. The instructions, I'm not going to read them all. We're just I'm going to go through a few things. I got a few pages I'm going to talk about, and then I'm going to sit down. I promise you, y'all can eat lunch. So stay with me. First one I want to talk about. I'm just going to talk about there's 7 counts of the indictment. Don't look at that. There are a bazillion lesser included offenses. Did y'all notice that when the judge was reading? I submit to you. You don't need them all because the state's proven the charges in the indictment. And if you agree with that, you don't need to look at the lessers because you just go with the count of the indictment. The first one, second-degree murder. We've talked about this. This is page 4. And remember, when we think about all of this, we have to think about that sort of umbrella of criminal responsibility. So every time you see defendant, that means any of these defendants or anyone for whom they are criminally responsible. Okay? So second-degree murder just has 2 things. Defendant unlawfully killed the alleged victim. The medical examiner, the brain trauma, those injuries were caused by the impacts of Emmett Martin. Soccer kicks, 5 haymakers to the head. That the defendant, Emmett Martin, or criminally responsible for his behavior, right? They're all out there. We're all doing it together. Certain people are holding, certain people are kicking, certain people are taunting. We got all sorts of things going on, but they're all engaged together. A attempts to aid or duty to prevent. That's second-degree murder. That's page 4. The next one, page 15, is the second count of the aggravated. This has been an intentionally or negligent check. The act resulted in serious bodily injury to Tyree Nichols. Check, right? 3, that the defendant committed the offense while acting in concert with 2 or more other persons. Check, right? The total of 5 officers involved in this, 5 officers listed in the indictment. We have to read on trial this week, but you've seen what Emmett Martin's doing out there, and you've heard from Officer Mills. The next count of the indictment, count 3, is on page. This probably of all the counts sounds the weirdest at first. You think about kidnapping, somebody grabs somebody and ties them up and puts them in the trunk of a car and drives across town and dumps them out. Clearly, that's not what we have here. So this is a sort of different way to think about kidnapping. So look at the elements of aggravated kidnapping here. And so this is count 3, is aggravated kidnapping with bodily injury, count 4 is gonna look just the same, except as an alternate theory, and it's aggravated kidnapping while you possess a weapon, okay? Okay, we can kind of look at these at the same time. That the defendant knowingly removed or confined Tyree Nichols unlawfully so as to interfere substantially with his liberty. There was a time that night. There was a time when those officers could have arrested Tyree. That would have been lawful. But that changed the minute we got that first soccer kick, that first use of excessive force.
All right. Yeah, I was tired of it skipping, and she explained that kidnapping charge that I had questions about earlier when they were bringing it up. So I went back to the audio. But yeah, she's explaining this kidnapping charge.
Where that spray goes, I don't know. I mean, watch it, you see. Like, I'm about to spray, watch out, meaning get back so you don't get sprayed, right? And you will see the first time he says that, Bean and Smith step back, completely let go of Tyree, and step back when he gets ready to spray. Okay? We're gonna watch it in just a second. Then he sprays. I don't know where that spray goes. I don't know. I mean, watch these.
I feel like I've heard this already.
He kind of steps out. He comes back in, and he says again, "Watch it, watch it." And they all three agree that every use of force.
Yeah, we've heard this already. Hold on. I didn't skip it to the right part.
1.77 grams. Do you remember TBI agent?
You're talking about them damn mushrooms.
20 or 30 seconds.
Where the fuck?
Keep in mind
I was definitely in
all
five
times.
something.
Not one.
I was in 5 something. Shit.
If it was,
I fucked up.
then it was unlawful. They give a mystery.
Okay, here she goes. She reading it.
That the defendant uses their official powers because we've had excessive force and no
Because she talked about kidnapping.
like confined, they're interfering. Dr. Ross talk about all the things that are happening in his body and how quickly that's happening. And then he goes into organ failure. By the time he gets to the hole, from that moment forward, everything that they do next. You can kind of look at these at the same time. That the defendant knowingly removed or confined Tyree Nichols unlawfully.
Okay, there it go.
So look at
She
the
explaining
elements of aggravated kidnapping here. And so
kidnapping.
this is count 3. It's aggravated kidnapping with bodily injury. And count 4 is going to look just the same, except it's an alternate theory and it's aggravated kidnapping while you possess a weapon. Okay, so we can kind of look at these.
Wait a damn minute.
That the defendant knowingly removed. Or
So wait a damn minute. Count 3 is aggravated kidnapping, and count 4 is aggravated kidnapping with a weapon. They just threw all types of shit out here, hoping something would stick. She knew that shit sounded crazy, so she had to explain why they would get a kidnapping charge.
Confined Tyree Nichols unlawfully so as to interfere substantially with his liberty.
They didn't unlawfully confine him, though. It was a traffic stop, and from the traffic stop, he was a fleeing suspect.
Is arguing that he was removed, right? It's that he's confined, it's that he's caught. And he's caught up against that car.
I can't wait to hear what the defense gonna say.
Unlawful.
She
There
was
was
cooking
time
for a
that-
minute.
There was a time when those officers could have arrested Tyree. That would have been lawful. But that changed the minute we got that first soccer kick, that first use of excessive force that no one does anything about. That's when it changes. It's when, from that moment forward, everything that they do next is unlawful. So when he's sitting propped up, his liberty is clearly interfered with. He's propped up against that car. And they're high-fiving right now. Nobody's rendering any aid. You heard the use of force experts that officers have a duty to render basic medical aid that they can. Nobody do anything. Really not doing it all. EMTs get there, nobody tells anything that's going on. So that's the kidnapping. It's when he's there cuffed,
That's the kidnapping.
liberty interfered with, he's confined. And you know,
So the state's contention is after he was finally restrained from 2 scuffles at 2 different scenes with the officers, his liberties were infringed upon and he was kidnapped because he was handcuffed and sitting up against the car awaiting medical treatment by the ambulance because they had already called the ambulance in. And that's what the state is going with. And the state wants a jury to find these people of murder, and they saying stupid shit like this. He was kidnapped after they finally got him in cuffs and sat him up against the car in the recovery position. Sat him up in recovery position and awaited for the ambulance to tend to him. He was still breathing. He was still alert. He was still talking while he was set up.
he has bodily injury. During that time, he's basically dying. We know by the time a paramedic gets there,
He basically died. He died a couple days later.
talk about all the things that are happening in his life and how quickly that's happening. And then he goes to the organ failure. By the time he gets to the hospital. So 23 is aggravated kidnapping with bodily injury, and page 32 is aggravated kidnapping with a deadly weapon. And again, the only difference you'll see here on page 32
It's a
under
weapon.
Number 2 is that the defendant possessed or threatened the use of deadly force. I'm sorry.
Now, what weapon are y'all alleging the officers use? Unless you saying the baton is a weapon, and that shouldn't apply to all 3 of them because only one of them used the baton. Nobody pulled out a
Use of a
gun.
deadly weapon.
He wasn't tased the second time.
Possess. All these officers have a gun. They possess a deadly weapon.
He wasn't pistol whipped.
They have him restrained
So just because,
unlawfully. They have him confined and are interfering.
so again, the state is reaching. Although, now again, I want to say these officers took a life intentionally, unintentionally. They still deserve some type of punishment. The state is grasping for straws so hard, they said that they kidnapped this man with 1 charge. Then they said kidnapped with a deadly weapon because all of them had their service revolvers or pistols or whatever you want to call them on. None of them pulled their weapons at all. None of them pulled their weapons, threatened to shoot them. None of that. But because it's part of their uniform, the state is saying, well, kidnapping with a weapon. I don't see this ending up too good for the prosecution.
So those are the 2 theories of aggravated kidnapping. One with bodily injury, one with a weapon. That takes us to official misconduct, count 5. And this is page 37. If anybody's following along, we'll put it up on the screen as well.
Count 5.
And at the top, you'll see official misconduct, unauthorized exercise of official power. Count 6 is another count of official misconduct with a different theory. We'll look at it next.
Come on with the
Unauthorized
defense.
exercise of official power.
She's getting on my nerves now.
You'll see them numbered. Defendant acted as a public servant. We know these are intermediate officers. Their oaths of office are part of the evidence you all will have. Number 2, defendant act relating to the defendant's office or employment that constituted an unauthorized exercise of official power. So from the moment of that first soccer kick. Everything going on out there. It's unlawful. And now it's unauthorized use of their official powers. Because we've had excessive force and nobody stopped it. Number three, that the defendant, and remember this is the defendant's plural, or the defendant, one who is, criminally responsible for, right? So, and then four, the defendant acted with the intent to obtain a benefit or to harm another. And clearly, Tyree is harmed. So that's the first count of official misconduct. The second count of official misconduct is on page 41. And this is an alternate theory. This is refraining from performing a duty. So it's all the same elements, 1, 2, 3, 4 that we just discussed, except number 2 is the different. That the defendant refrained from performing a duty that was imposed by law or that was clearly inherent in the nature of the office or employment. Refraining from performing a duty. These guys had a duty to inform the EMT about what was going on, about what they've done, about what kind of care the staff did. Nobody did. And that takes us to the last count, count 7, page 44.
Seven counts.
It has 2 elements. That the defendant was a public servant acting under color of office or employment. Yes, these are MPD officers in uniform. That the defendant intentionally subjected another to mistreatment or to arrest, detention, stop, frisk, halt, search, seizure, or dispossession that the defendant knew was unlawful. I'm going to go with mistreatment. Tyree was subjected to mistreatment. I promise I'm almost done. The last one we're going to look at is kind of where we started. Page 58, criminal responsibility. Different ways you can be criminally responsible for the conduct of another. Direct aid, attempt to aid, focus on those. Duties to prevent, permission to be offense. Okay? Do you remember this week when we watched sort of a little animated video? Then Smith put it on, and it was like a cartoon thing where it only showed what Smith was doing. Turn that video. That's not what happened out there. It's 5 officers acting together. If it was one officer out there, would we be here? No. If it was just Justin Smith in that animated video, no, that's not real life. That's an animated video. It's a vacuum. Every step of the way, you'll see all these videos. What do you see? You see these officers working together. Hold an arm while he's getting punched. Hold him down while he's getting soccer kicked. At the end, after he's on the ground, 3 officers on top of him. That's when we got hate rolling. Beat that man's ass, kick, another kick. All 5 officers. Not one. All 5. But it's not just their actions that you have to look at. You also have to look at their omissions. That the duty after every one of those impacts, and I count 9. 2 kicks, 5 haymakers, 2 more kicks, 4 total kicks, 5 total punches. Every one of those requires the duty to prevent, the duty to intervene. That's part of criminal responsibility. Not one.
What the hell is going on with their mics? So like the ocean waves.
As soon as it's over, we start fist bumping, we start high-fiving, we start playing back what we all did. It's so great. Ladies and gentlemen, in our opening, Mr. Hagman told you these men aren't monsters. We're not here to tell you they are. You heard from a bunch of character witnesses for Ian Smith. So they're great guys? Good officers? Okay. What we're here to talk about is what happened on January 7th, 2023. And not one of those character witnesses was on the scene that night. I told you last week, it came up when we were still in Chattanooga, something about the jury voting good or bad. That's not what you go back there to do. Not good or bad, not right or wrong. But did the state carry their burden in proving these 7 counts? Did they prove that these 3 officers did what we say they did on January 7th, 2023, are good people capable of doing bad things? That night, January 7th, 2023, those 3 officers did bad things. And when Tyree cried for help, nobody helped. Nobody presented. Thank you.
All right, ladies and gentlemen, we're gonna go ahead and take a break at this time. I know that time of lunch. We will call you all back in. We're ready to get started again.
5:16. They went to lunch. Let's see here where we end up. Did she rest her shit? How the hell I ended up right back there? I don't think she rested her shit. Well, for an hour afterwards.
Do you know anything about
Okay, the defense kick it off. They'll go for about an hour. Yeah, I'm getting sleepy, so I'm gonna finish this last hour, and then I see y'all in the morning to finish the second part of the deliberations, because most of the day that they did today would have been, or yesterday would have been the jury. After they got through with closing statements, they were deliberating and they ended. So in the morning, while I'm finishing the closing statements, maybe we'll get a verdict back and I'll be able to do that real time.
Welcome back, ladies and gentlemen, of our jury. This is, as we talked about, sometimes the difficult part after eating a big lunch, having to sit down in here and listen. But we're going to ask for you all to be
Got the itis. Why y'all give them a big lunch? Should have got them salads.
January 7th, 2023, 30 more minutes. The Darius Bain didn't know anything about Tyree Nichols. He didn't know anything about what Tyree Nichols had done at that time. He didn't know anything about the fact that months earlier, Tyree Nichols drove from 285 Riverdale all the way to Ross, the rains, while having blue lights cut on at first. It didn't cut off because Memphis has no chase policy. At 8:30, Chris Bain was not known whether or not Tyree Nichols had a gun, whether or not he had a knife, whether or not he knew self-defense. He didn't know whether he had murdered anybody. He didn't know whether or not he had kidnapped somebody or carjacked somebody. Because those are things that Tyree Bain has to interact with on a nightly basis. Those are the types of arrests that he's made. At 8:30, Tyree Bain was a passenger in a vehicle and had a person in handcuffs because they had a warrant. And he hears that a person has been tased and pepper sprayed and had gotten away from his fellow officer. That's all that Tyree Bain knew. So at 8:30, 2 on that same evening, while he's a passenger looking into the night for a suspect, not knowing what he had done or who he had done it to, he looks out the window and sees the person who meets that description. Tyree Bain, after he saw that suspect and met that description, would have a faith that would never sell him with somebody who, according to his mom, didn't have it all together. At 8:32, Tyree Bain, not knowing anything about this man, did this.
Are we back to the damn video? I was finna let the black defense attorney cook, but man, he going back to the video. I don't want to see that
He
shit
sees
no
a
more.
person that meets a description and he runs to get that person. No more, no less.
He doesn't know anything about this. He doesn't know if this is anything that's wrong. None of those items belong to that man, but he doesn't know that. All he knows is that this person, after being lawfully stopped and attempted to be searched, took off money and overcame 3 grown men, and he attempts to do his job. I told you at the beginning that the law in this case would come from the judge, and that hasn't changed. But the facts come from this stand. And the facts, if turning red on this, all support.
All right, let me try y'all again. 653. All right. Let me see if I can get the last hour of juice out of this screen share. Let me see. Calling me now.
And that hasn't changed. But the facts come from this stand. And the facts, if turning red on this, all support not guilty verdicts on all counts for Darius Bean. Every witness supported Bean's not guilty. Every one of them. When asked about him holding this person and why he's holding him, every witness says the same thing. You can't let a person go if he has one cuff on and one cuff off. You just can't do it. Every witness, all of the documentary evidence supports Bean being not guilty. You see those items that are stolen. That's from the person who Bean doesn't hint him. You heard from the state's witness, Mills, then he kept
I'm here, y'all. I'm trying to get the last hour to play. It's giving me trouble. I'm here, y'all. Shut up, me.
not only did you hear from him, but afterwards, when you hear this conversation, the so-called high-fiving about what happened, you hear, and during that conversation, Bean talking about his eyes burning. But in addition to talking about his eyes burning, he also talks about the fact that I bust my shit again too, meaning his knee. And you'll hear him talk about how the sutures in his knee open while he's out there on that particular night. You'll hear that. No, or you heard rather, there's no direct proof of any kicks coming from Bean whatsoever. The only strikes, if you slow it down and you take it at a quarter speed in particular, you see that all strikes are to the forearm after Tyree Nichols is turned over and is reaching up. He pushes the officers off of him while he's on the ground, and they're asking for him to get on his stomach so they can put cuffs on him. It's impractical and dangerous for Bean to let the suspect's hands go. And you heard about the one handcuff on, and you saw the experts in the case. And once again, you should judge Bean's actions based off of the training that he received, and you saw the evidence regarding the training. Scorpion unit, once again, the evidence supports the fact that it was a street crime operation and to apprehend guns, dope, and money, and they were being told how successful it was. Created in 2021, and it consisted of several teams. And you also heard from both witnesses about how Team 1 was sent to the most dangerous places in response to the most dangerous spikes in crime.
And you heard from Mills and Hempfield regarding how they were being congratulated from the brass at the top about the effectiveness of the unit. You had to be selected into the unit. They didn't just ask you that, well, you want to apply to the Scorpion team. They would come and talk to your superiors and ask you, does this person have the type of character and abilities to serve on this type of interactive team? Let's go back to those actions on January 7th. Just like what came from the witnesses, they met on Flickr at 6 for roll call. They were signed out in that East Memphis area due to the spike in auto burglaries and thefts, carjacking. A person driving away from blue lights is indicative of those types of activities. Detective Bean was part at around 8:30 to take a person in custody with warrants, and they let the misdemeanor warrants go in order to respond to that other location. And the suspect had been tased in pepper spray. That comes out over the radio. So that's what their interactions are based on. Detective Bean and Mills see the person, and you saw earlier at 8:32, Bean makes contact from inside his car with him visually, and when he tries to speak to him, the guy takes off running. And then you see that 3-minute struggle. Now, Detective Bean and Detective Justice Smith get to the person almost simultaneously, but Detective Bean doesn't know Justice Smith as he got contact with him and made the decision to run away from him. That's all that he knows, and he tries to apprehend him. He used the use of force continuation to hard hands, and you don't have to go step by step. They can jump in escalation. Use of pepper spray, the use of verbal judo, the use of hard hands slapping a person's wrist. None of those are out of the ordinary or anything wrong. Once the suspect was finally secured and handcuffed, and you look at the videos yourself, when handcuffs went on this, no kick, nobody came up and got an extra punch, came up anything inappropriate. Once the handcuffs were on, the interaction was over. You get a chance to, when you're back there, review the policy that's been submitted as evidence. You heard from the experts regarding active and passive training, high-risk stops, the response to resistance within that policy, how hard hands and kicks and punches and slaps are a part of the hard hand apprehension process, and the use of force continuum. You heard about tunnel vision, non-lethal force, training in taser usage. The only person that had a taser on that team was Hempfield at that time, and how the taser prongs, how the taser hit him. He says, and you'll hear the videos, I hit the bastard. Now here, after being questioned, and as he used the term, and I used it, browbeat, he says he didn't know for sure where they hit him. You judge by the video whether or not it looks like a taser's hit. It's that simple. You heard from, and I asked the question of the expert, Mr. Cameron, regarding ineffective force versus excessive, because he's written about it and he's presented about it. Ineffective, if you're looking from a sky cam, looks the same as excessive. It just does. If it's not working, it looks excessive. But when you look at the body-worn cameras, you have to do it in order to appreciate what they're trying to do and what they're going through and trying to get the guy into custody. It's showing they're not trying to punish somebody on the side of the road because you got this person's ID, or you got this person, you were involved in a crime, and we're just gonna beat the heck out of you. That's not what this was about. This was trying to get this man into handcuffs. Mr. Mills regrets using his aspartame, and I'm sure he regrets the verbiage that he used. I wanted him to testify, and he did so, about the time in which he changed his plea, because his initial statement was it was by the book. He didn't have the access of the book and looking at it and all that stuff at the time. This was a mere day or two afterwards, and he talked about how he responded and how he acted. But after hours and hours with the Department of Justice, and somebody saying, well, it sounds like you're pissed off. Yeah, it does, all of a sudden change to, well, maybe I shouldn't have used the aspartame. But in fact, he used the aspartame verbatim the way the MPD teaches you. 3 strikes to the arms. Nobody hit this man in the head with an aspartame or with any other instrument. He does not get struck with that aspartame where they train you, between here and here. And you'll have the opportunity to go back and look at Mills' body-worn camera in order to assess that. And it's important that you do, because it tells the story as how they are moving away from the person, and he still hasn't come into compliance with their request. The use of an aspartame happens. The witnesses in the case, when doing the opening presentation, you don't really know exactly how much a person might be incentivized by the fact that if you're looking at life and you know negotiated down to no more than 15, etc., that might play a role in saying, well, you know what, I'm gonna stretch the truth this far against them. But Mills was honest. He said that their use of force, according to him, when they're older, and when I asked him about it, can they let go to talk about somebody striking a person at that time? He said no. The danger is still there for the officers until the handcuffs or the bracelets, as they call them, are on the person. We talked about the fact that being, you'll have an instruction regarding character witnesses. Nobody refutes the fact that being had a car, if they say you can't get a hamburger in your issued car. The fact that the person who came in from Mr. Taylor from college said that, hey, even when there was a little money missing, this, that, or the other, he took it so seriously that he came and got me from across campus at the law school and said, how do I deal with this? Let's go to the bank. I want this done immediately. That's the type of person that he is. Then you hear from Mr. McKinney, the one who had the pepper spray. We had they were in the same class. I wanted him to talk to you about how the effect that it had on him. You'll see how it affected him. But he talked about Mr. Bean's character. That is stellar. You heard from his FTO trainer, a field training officer. He's one of his favorite persons that he has trained through the years because you tell him one time how to do it, and that's how he's going to do it personally. You're the experts. The state didn't produce an expert. Think about that. The funds and things that the state might have at their availability can't find one person to say to you all that Darius Bean's actions were inappropriate. You can say it, Bo. You can tear it up. You can almost cry about it. You can say he just wanted to get the good old cheap. But it does not change the fact that Darius Bean acted the way that he's supposed to degree of respect from his Wells. I didn't ask her a question. She lost her son. I understand that. Any mother who loses a son, obviously, would have pain. But driving is a privilege. A person cannot take that privilege to do whatever it might be. Driving, having to stop for blue lights, getting out of a car and acting like you might have done things that you didn't do. They don't know the answers to that as public servants while they are trying. It's not fair. And then look at the videos. Keep in mind, and it's kind of underscored when Ms. Headley was discussing it earlier, but Bean cuts that video off. The video does not all of a sudden get volume a minute later. The body-worn camera is constantly recording, and then once you trigger it, it keeps the recording instead of recording over it. That's why the volume doesn't come on for a minute. So after he's in the course of running towards this person, supposedly going to do something to him, and gets to Nichols, is in that scuffle where Mr. Nichols is constantly reaching up and knocks it off. But that's his triggered body-worn camera. The officers were aware, and you heard Mr. Mills say, well, I didn't know it for days later. Of Department of Justice, then it might change to a shock me moment. Yeah, that was the first time I knew about it. But there's been no testimony as to whether or not Darius Bean knew that there was a recording. What we do know is that yes, this is an isolation of the punches that we're talking about in this tape from the sky camera, the Skycop camera time. And so it just outlines the force that's used. Two different kicks. You can't tell whether they land, and Ms. Headley talked about a thud on a camera, from the sound of a camera. That's not the same as looking at something and telling whether or not that type of force was administered. And you definitely don't know whether or not it's being seen while Darius Bean is looking down at this guy trying to bend his arm. And if you'll not stand in a location around Mr. Nichols to make this aspeton have to hit him in the head. They cleared so he could get to the place where they tell you to administer the blow to the arm. That's why they get out of the way like that. And that's how you're supposed to. Then it appears that Martin slaps him with an open hand, and then Martin hits him. And nobody is here to say Martin did not hit him. Martin's not here. So as to what was going on in his mind and what he thought he was going to do, there's seconds can all of a sudden say, hey, time out, everybody. Y'all stop. Everybody stop. And know whether or not Mr. Nichols is just going to stand there and say, we're all good now. You can put the handcuffs on me. But what I do know, through those sounds, after the hitting, he failed when they put him to the ground, and the interaction stopped while he's back on the ground. They're on him still trying to get the handcuffs on him, and they still can't get it until somebody comes in so that they can get him steady enough to put the handcuffs on him. And when you're looking at it, look at it from the fact that you're trying not to break his arm or dislocate his arm. That's what the concern with Darius Bean is, and you can tell by the body movements. They're trying not to hurt his arms. That's what they're focusing on. They're trying. It's that simple. There's a lot of Tyree Nichols is 6'3" according to the hospital records. According to the records, he's 180 and he's 6'3". Next. I indicated that I would not talk about what he was before or after that night because I'm not concerned with trying to in any way say so y'all hadn't lived here that long or what have you. This person's ID says that he lives here. And eventually they say, okay, what's going on? They don't know what all he's into. But there definitely had to have been something that this person.
Hold on, y'all. Let me stop it and then bring it back up. He was cooking for a minute there. He was cooking. Hold on. Yeah, it's too close to the end for it to be doing this shit. It's the last attempt. And then I'll just go audio. The last 40 minutes or however. Yeah, 41 minutes.
Person said, I don't know. So you're expecting Mr. Bean to know the level of force and the level of coercion that it would take to get this man in the handcuffs with his own folks say to get on the. We know that he did drive 2 miles away from the blue lights and sirens. You'll see the reenactment. You heard the testimony of Mr. Hempfield, and you'll see the videos that are involved, and you'll see the camera inside the car of Mr. Martin. You know that he ran from the first scene, and he ran from Detective Bean. That was from the testimony of Hempfield and from Mr. Mills. Nichols drove in a manner to avoid police detention. That's according to Mr. Hempfield's testimony. We know that he refused to stop, and he subsequently resist arrest. Mr. Nichols opened the car and the stolen credit cards and the stolen ID. Does he have a right to resist being stopped? All of the experts say that he doesn't. Ms. Headley says that he doesn't, and I agree that he doesn't. Does he ignore lawful commands for his hands to be handcuffed? All 3 experts said that he did. He from Detective Bean, yes. And that's according to all of the experts that are involved. And the actions at 6705 Ross Ridge are important because they show that this is not just somebody trying to get home for chicken or whatever it might be. This is the actions of a person who's doing whatever he is between those cars, trying to avoid being arrested. They don't know that. They don't have the ability to stick inside of his mind. They don't have the ability to even know he's out there. 6705. They know that he's gotten away from them, and they're trying to bring him in. That's all. Darius Bean is on trial. He goes to the academy. He gets out of the academy. He's riding with Mr. Turner. He started out as a patrolman 2. Mr. Turner was an FTO officer. He had no write-ups while he's in that precinct. He had no complaints against him. This is not only while he's in the precinct, but while he's a member of the Scorpion team. He had no issues or accusations of misconduct. Keep in mind, this is not some case when they're talking about, because you'll look at the official oppression, the oppression chart. This is not some case where they're out trying to beat up guys that are accused of selling drugs or dealers, or to try to beat up somebody behind an alley because allegedly he did something wrong or that they disagree with. This is simply textbook police work where you're trying to get a man into custody that is resistant. And you can't do it. And he took his job. You'll have the 7 charges, and I think you got 35 different subsections. Sometimes people say, well, we don't think that it was second-degree murder. We think that it was reckless homicide, etc. All of those charges require some form of intent or recklessness. And keep that in mind. So the word that you will see in those charges will show that it can't just be, well, we got to, us 3 want all acquittal. And the rest of us say, well, we should give the family something. These are not compromise charges. These are charges that have to be met until they give violence to in this.
All right, y'all, give me a second. Let me make sure I know exactly where it is. 716. And I gotta fuck up like I did last time. 716. All right. I'm gonna just play the audio to end it out. He ain't did nothing.
There are any people that think that they can do anything. Number one, they in response to a distress call, the way he's trained. Do you want your officers not to do that? Number two, there's no plan to harm anybody. All of them said the same thing. There was no conspiracy or, hey, first guy we get tonight, we're gonna try to beat the hell out of him. There was no discussion about Nichols whatsoever. Number three, he chases the suspect as he's trained down a dark street. He doesn't know what he has. He relies on his courage out of that night and covered back on like the poet would say. He did that on his own as he was trained. Knows the suspect has overpowered 3 officers. That's what the call out is. He knows that that's dangerous. Number four, only hits the suspect's hands. There are times that if they wanted to beat or pummel this dude or break his nose or break his neck, they had that opportunity. When Tyree Bean and Justin Smith are trying to get his hands, why not just start wailing on him? Hit him in the jaw, hit him in the face, kicking him, stomping him out. Did they do that? Y'all saw the videos. That's not what happened. Next number, 3 experts and police officers all agree with Bean's actions, that they were appropriate under those circumstances. There's no conversation about injuring or restraining or training or chilling Nichols at all from any of their witnesses. Bean manually and intentionally activates his body worn count. So to do all of these 7 things they're saying that they're accusing him of doing, he wanted to record it. So in addition to being this great guy and everything that they make fun of, he's an idiot. He wants to record himself, create these or commit these criminal acts according to them. Bean acknowledged Nichols' strength. You get the conversations after. These high five conversations, which is this? He's the hardest dude that we've had to arrest. And I'm gonna, excuse my French, and I'm gonna just try to talk to y'all plain and forgive me. And if anybody
Let him cook.
I apologize for the cuss. But they are out there wondering, to use her words, what the fuck is going on? When Ronald Bell said she had to look at her son, she wanted to know what the fuck was going on. They wanted to know it. That's what they're saying back behind the truck. Man, he's high as fuck. God damn. Man, I bust my shit again. Man, I had to help him out. I think I'm supposed to be off tonight. That's what these public servants are discussing. Where she's saying that it's high five and beer time, they're discussing this guy who, out of all those different arrests that they've had, have never had this type of issue. This is another thing. Hardcore, hard dope dealers and thugs or whatever you might want to call them, like that. When they get to the police and the police say, put a hand behind that, you know what they do? They might be saying, I'm gonna call John and see if he can get me out of this. But they don't do what he did. That's not him trying to be some martyr. That's him, for whatever reason, thinking that he's more important than the process. Being observed, Nichols ignored these lawful commands. So while they're saying, hey,
the defense cooking.
We need to stop trying to hit him. He's supposed to overcome his own emotion, trying to get this guy into custody, his own adrenaline, his own fatigue, and be able to say, man, his own eyes burning, and then say, hey, y'all, you can't hit, don't hit. Because I think there's some human factors that one of the experts talked about, which is with being observed Nichols gather his legs up. Remember when he's on the ground and they seemingly would have come into some compliance under, you heard Mr. Mills talking about what the aspartame does. What's his response to it? He still stands up and tries to walk off. Now, in this instance, in this case, because of the case and all that stuff, is, he can try to run because he's scared of these officers. Does that make sense? Ask yourselves when you're discussing it. He's just so scared that he wants to stand up and walk off from these officers as opposed to turning over, putting his hand behind his back, and allowing the custody to go on. Witnesses testified that Bean is by the book. No prior instances like we talked about before. Nichols was motivated to flee and fight. He's got dope, stolen credit cards, and stolen IDs. That's a motivation for him to act like he did. Once the handcuffs were on, who struck him again? Who kicked him? Who talked bad to him? Not a single person once the handcuffs were on. There's no DNA evidence regarding Bean whatsoever. And what benefit would Bean have from injuring Mr. Nichols? What benefit to him? There's nothing here that indicates that he would have gotten any sort of thrill out of it or any sort of money gain, nothing. So when you look at these 20-some-odd reasons, think about this one also. Think about the video of 6705 Ross Ridge, where Nichols is not yelling for neighbors to come help him or not running his tail off to get to home and all of that. he's dodging between cars. And you heard the testimony from Mr. Baker that nobody ever went out there to see if there was anybody else's credit cards or anybody or any items that would help you break into a car and steal these credit cards. Nobody ever searches or does anything regarding that because the focus was on how it looked and the possible public outcry. That's what the focus was on. And the investigation from the gate was biased. It wasn't any focus about both sides of it. It was all the rumors that might be out there about what these guys might have wanted to do and all this type of stuff, but nothing about how difficult it was to bring this guy into custody. This is only, and this will not go back to you for evidentiary purposes, but I want to give emphasis to it because it shows where he is, and you'll have your own individual notes. And this is during the time that there were any strikes rendered. And this is based off of the overhead of the Skycam video. The time that the pepper spray goes all these different ways, Bean's eyes are still blurred and burning, but he has to have a hand on this suspect that has run off in 2 different locations. And he does that. And that's at 20:33.
I'm gonna just point out, I ain't on the defense team. I'm gonna just point out, at no time during this altercation did any of those 5 officers pull their gun. They did not. The guy with the baton, he hit him 3 times in the arm and put it up. So it wasn't like he just kept welling and all of that. I agree. The kicks, the people that kicked the excessive force, there was 2 officers, there's 3 of them on trial now. The 2 that kicked, definitely out of order because he was on the ground. The punching, that's just part of fighting the suspect. That happens. And when they up or down, that's part of the game. Punching, that's not excessive force. If y'all in a tussle, it's not. If the suspect ain't fighting and you're just punching them, yeah, excessive. But if it's a tussle and the police is fighting you back and you fighting them, that's not excessive force. The ones that kick, yes. But is there excessive force enough for them to be charged with murder? Man, they're just showing that animated video again. It's not actually real, it's an animation.
This is the time of the video you hear Mr. Smith yelling out the different, trying to read the locations. Bean is still with his hands on the person. He's not looking at Martin or what Martin's about to do or can do. His focus is down, and you look at where his head is, it's down. And that's at 20, 34, and 12 seconds. And when you slow it down, slow it to a quarter and see if you can tell whether or not the kick connects to him on either of those kicks. Y'all do it back there. You have the ability, it's the evidence that you got away. But look at it for those purposes as well.
Yeah, he's still showing the animated
Nichols is
video.
walking off, trying to regather his breathing. Bean and Smith don't have that luxury. They don't have that luxury to gather their breaths.
Let him cook.
And all this time, could have turned on his stomach and got the handcuffs behind his back and just doesn't do it. This is when the first blow from the baton. You'll see the one hand is gathered by Mr. Bean, and he's holding it as the other is attempting to put the handcuff on. That's the 20, 34, and 56 on the Skycam video. This is the second blow from the baton. Same position, and he's holding that arm. The suspect is still done what the expert referred to as blading his body, having his body on the side, not on his stomach, trying to get handcuffs on. Mr. Nichols stands up on on his own, and they don't have the luxury of saying, hey, this is better walk home so we can go up the street. They don't know where he is. They're holding on to him because they do not want this suspect to get arrested.
Damn, it's 2
When you're at
o'clock.
2035-08, analysts on the jury and people that are athletic and understand center of gravity, look at how he's pulling when you look at the video and you isolate it at that time. This is at 2035-09, and it's more definitive than just a few seconds ago. You'll see his center of gravity, Mr. Bean's center of gravity, 2035-09, where he's actively pulling the man away. Away from any kind of blows from. This is where center of gravity gets lowest. Now imagine that you're pulling somebody like this and they got the strength to not go with your pull. That's where it comes about. Man, he's strong as an elephant. He's strong as hell. That's what the other folks say. All he's saying when they're up there is, man, he was eating. That's what they are offended by. The fact that after dealing with all of this, they say, you know, a person takes pepper spray, punches, etc. Man, he just was eating that stuff because it looked like he was high to them. And as he tries to walk away, Bean grabs that right arm and says, no, you can't walk away as a suspect. Just can't do it. Because at this point, I don't know what you have done and why you have done it. Why are you acting like this? I don't know That's it. That is what you'll see on the videos that offends the state, and I understand that, and this is their case. But this is their case, and this is their burden of proof. Criminal defense cases are criminal cases. You have the highest burden of proof in history of mankind. Proof beyond a reasonable doubt. It's not a standard where you're across the street and trying to get custody, or if you're trying to get money on a case where preponderance of the evidence, etc. Proof beyond a reasonable doubt. This case, more than any that I've ever had, is not only in this gray area, blue area, it's not in here where it would be not guilty. It's down here, proven it's not guilty. He videotaped himself, but you got the witness. And then with Mills, Mills' first witness that they called. That was a fact witness. No plan, no plot, no conspiracy, no knowledge of what Bean was doing. I mean, what Nichols was doing, I'm sorry. You don't have Bean in the car mad, talking about, man, I don't want to be on work tonight. I'm sick of this stuff. I'm sick of the city. I'm sick of the problems that they put us on the front line to deal with. None of that. Just a regular night. They're going about their job. Mills did not testify that Bean used excessive force. To the contrary, he said that his force was appropriate. Hempfield, same thing. I've never seen Bean use excessive force. I've never heard him talk about any kind of street tax. I've never seen him upset. He was a good, quiet officer that minded his business and did his work. That's their testimony. Hempfield had the ability to make up stuff for what that is. He said, you know, and everybody doesn't have people that are in the upper echelons of the police department to tell them. But he wasn't going to kowtow to what the Department of Justice said. He stuck with his story. This is what happened. I wasn't on that second scene, but I know what he was like on the first scene. I know how strong he was. I know he wasn't doing what we asked him to do. I know he was speeding. I know he was changing lanes appropriately. I know that we followed him 2.5 miles to another location after he thought we had turned off. He stuck with his guns. He ain't facing that type of stuff. So he's smarter in this situation. But he testified favorably regarding Tyree Bean. So Matthew testified they weren't officers. So these aren't a group of guys that's just out here jumping out of cars and trying to fight somebody or do something wrong with somebody or a vigilante group. These are sworn police officers. Matthew, proven not guilty. Robert Long. I don't want to downplay what Robert Long said, but as it relates to Tyree Bean, he didn't interfere with any of the assistance given. You see him lifting this guy up, and he was exhausted. And if you don't think he's exhausted after running that many yards and somebody, count the steps. I counted 93 steps. 93 steps with 40 pounds of ammunition on and a duty belt. You think that that's just a fun night that we want to go out and terrorize somebody? But Robert Long said he wasn't a hindrance. He wasn't in the way. He did what he was supposed to do. Testified favorably for Tyree Bean. Greg Turner. He's my favorite. That's his word. Trainee. He was studious. I told him what to do one time. I didn't have to tell him again. I was his beginning FTO officer. I was his release into the field secondary FTO officer. And I worked with him for the 2 years that he was in my precinct. Never an issue with it. It's no surprise that they plan talking about Tyree. You need you on the Scorpion unit. We need you dealing with the issues that Memphis has. He testified for Tyree's things. DNA expert. No DNA expert talking about what all he did and I'm glad I can barely say what the ribonucleic acid, or whatever. I can't say any of that. Why? Because there's no evidence regarding Tyree's thing. Proven not guilty. Keep down Taylor. I'm jumping back to the character witness. You're in college. You're at a time that, you might want to get it together. He wasn't 29 years old, he was 20. But he had it together. He had his act together. In college. That's a character person. That's not somebody out playing games at night. That's a character person that has what it takes to have been a sworn MPD officer that wants to work and get home at night. Proven not guilty. Marco Ross. Was there any evidence about anything that Bing did regarding any strikes to the head? No, they want to say that Bing, while he's holding this guy who is broken away from 3 officers already, is supposed to be responsible for what kind of day Detective Martin might be having. But we know one thing, that blows to the wrist didn't cause it. Blows to the wrist didn't kill it. Marco Ross, he testified in favor of Tadarius Bing. Jordan Rogers. Jeffrey Rogers. Might forget the names, but we know one thing, they didn't know Tyree Nichols. We know that. We know that he had their stuff in their car. We know that. We know that they didn't get a ride from them to forget their purses on the head. Why do we know that? Because this stuff happened back in October. This stuff happened back in Halloween. And ironically, the stuff is stolen on the same night and happens to be in the same person's car. I mean, y'all are 12 people, and I don't know, 14 this time, it'll be 12 next. I don't know who's smarter or who's not, but you're smart enough to have made it here. Not smarter than I am, but I can figure this. The stuff didn't belong to Tyree Nichols, and it's in his car. So whether or not it's Sesame Chicken or trying to get away with their stuff, they testified in favor of Tyree.
Did he say Sesame Chicken? The Memphis came out this nigga.
It's Ricky. I don't know how it was Ricky did. Ricky, a lot of shit not probably him. And, law enforcement was about 15 years ago. But I know right from right. I know wrong from wrong. I know what they were doing was right. I know that you have to focus on what you have to focus on. Why? Because as soon as you don't, this guy might not be trying to get Sesame Chicken. It might have a pistol in his pocket and blow your brain.
Sesame Chicken. He did. He been watching NBA on TNT.
They make a mistake at their table. They can come and say, we should ask this. That was a bad analogy. Let's do it this way. They can have those conversations. They can have those conversations for an hour. They can talk to you 2 hours about an incident that took place for 3 minutes. Tyree Nichols can't do that because he'll get his head blown off. He doesn't have the choice of whether or not this man has it together. He does not have the ability to make that assessment. The games have to stop. All 3. Because the state wanted them to, when asked questions regarding the circumstances that they were facing, testified in favor of proven not guilty. I chose McKinney last, but next to last. Because McKinney knew him from the academy, and he also testified about the eyes and how it feels. And you'll see his video back there. But he testified about this situation. Young man just said, character is when nobody knows what you're doing. Character is what you do when the lights are off. Character is what you do when ain't nobody else watching. That's what character is. Wasn't nobody watching that car when he said, hey man, come get me and run me a mile up the road. That's character. That is a person who has a fiber in him that nobody else can define for him. So when the New York Times do call me and say, hey, I want to do a story on your parent, on the parents to see what they did up there, you know what I can say to them? I can say, hey man, if I'm his parent, I'm jumping up and down with pride that my guy can get out of a car and run after somebody who he knows nothing about. That's what he's sworn to do. I'm not asking the door and saying, hey, does Tyree Nichols live here? No. And these are good people now. These are good people. Good neighborhood. Solid man. His son just works for his son. I don't know him. I don't want his problems here. I don't know him. You think about that. Police knock at your door about children. I don't know the man. I'm sorry. I got to do it. I'm kidding.
Uh-oh.
If her son wasn't together at 29 years old and he's out on the street and he's running from where the police are, if he's running from them, I'm sorry. If he doesn't have it together and he should have it together, I apologize to her. She's a good woman. Doesn't bother me because I be cussing about my son fighting his game. They don't bother me. But I know one thing. He didn't have it together. Tyree Nichols had it together. She testified for not guilty. She testified not guilty. So this is where we are. I don't know how to sound that.
My nigga angry.
But I'm about to beg. because I don't have a vote. I don't have the ability to stand back there and to say what's right, what's wrong, or anything. I spent 5 days in your city, and I respect you guys for coming down here and being willing not to make up some stupid.
Oh, you ain't even from the city, Sesame Chicken. He ain't even from here.
Worry about not wanting to do it and overcoming whatever it is that is an imposition in your lives, because you got lives that you can be at home dealing with. John Sr., my dad, taught me not to be jealous. Not to be jealous. Don't go to somebody's house and come here talking about, man, I wish we had that TV. Nah. I couldn't do that. Not around him. He wanted me to have to take care of it. It's a very thing has. But I gotta be frank with you. When I did my Monday morning, Tuesday morning, this morning, I would walk around that square where the aquatic center is. And when they set up the festival on that Friday morning, I don't even know what the name of the festival is. I got jealous. That city's right. That city's right. Now, this city has some leaders. And this city has some leaders that I love. And there's some leaders that I love that are on the opposite side of what happened out there on that side.
What the fuck aquatic center is this nigga talking about? We just got the zoo, and that ain't nowhere no food festival set up that he talking about. He lying.
Respect that. I gotta respect that. But I also gotta respect the fact that in this particular case, you got 5 guys that are doing their damage to get home. I got one that I represent, that I am at the proudest moment of my life to represent him, because he did what I don't know if I would have the courage to do. He got out of the car and he grabbed the guy that he thought had done something wrong. Now, he's done it all these other times and it wasn't a problem. But on this particular night, because of how he looks afterwards, after this man had 56 times that they asked him for his hands and refused to do it because of that public outcry, or whatever it might be, he's got to sit here in front of you all. He has to have.
I don't know how much this nigga got paid,
So you got all these
but he
different
is
subsets.
cooking.
While you look at those different subsets, I challenge each one of you, and at the end of it to discuss it, because the judge said, like, you got to read all that stuff, and you're supposed to read it, and it is expected to read it. But it should be just as easy as he did to jump out that car on each one, not guilty, in the sign. On the count 2, where it talks about the kidnapping, it should be just as easy. On each one of these pages, you'll have the chance to strike, not guilty. Not guilty, oppression. Not guilty, aggravated assault. Not guilty, especially kidnapping. Any of those different charges is simple. You've sworn yourself to do it. You don't owe anybody anything as it relates to sympathies. It's an easy task in this particular case. It's right or wrong. And there's no way to say that, hey, we've gotten to a date in our society and in our world that we can't appreciate the fact that our public officials put their lives on the line for us each day, and they're trying to do right. So it's not a case where they're abusing the badge and trying to go out there and prove a point, or to try to kill somebody or something like that because I'm trying to rob this notebook. It's not that case. It's simple as ABC. I'm asking this man to do a task. I'm asking him to give me his hands so I can put the handbrace on, and he's not doing it. And I'm trying my best not to break an arm, break a leg. I'm doing everything I know how to do. And you're asking me to be more responsible about somebody else's actions at that particular time and risk my own life is too much to ask. That's why I'm jumping. If you act this together, I'm asking that you help us out on this thing. That you, at the end of the day, make this an easy journey. Get back to where your lives are. It makes us have to have what it takes to do the right thing in this case. Overcoming any sort of public sympathies and things like that is simple. Everything is not guilty. And in this case, it's not even a close not guilty. It's proven innocent. Thank you.
This nigga is Johnny Cochran Jr. That boy good. Yeah, they finna be done for the day because it's only 7 minutes left, and they're not gonna let the other 2 defense attorneys do their spiel. So that's what I do in the morning, 8:30, 9 o'clock ish, somewhere around that time. I'll do that, and hopefully while we're listening to that, while we're in the middle of listening to that, we'll see if a verdict comes about. To the next episode, we out. Never been a hoe, I stay on ghost on what the business. Nigga talking reckless, shoot his bitch ass with the quickness. Now he bleeding, sorry, begging, asking for forgiveness.